to just say that if we are successful, the planning permission that has been granted by the council will be quashed, and the council will then have to reconsider their decision, and hopefully that will be in the light of the TAG report, etc. So and resident elections, etc. So that's what we're hoping to achieve by the judicial review proceedings, is to quash the planning permission. As John said, we have got permission to run judicial review proceedings by the court. There is a sort of filter process in judicial review proceedings where the court looks at what grounds we have set out for saying why the decision is unlawful, and if they think we've got it's unarguable, then they would have refused us permission. As it is, they've granted us permission, so the court thinks that our case is arguable, and they have, as John explained, imposed this protective costs order, which means that if John loses, he won't have to pay more than £10,000 towards the council's costs. He'll have his own costs, TRAG's own costs to pay for solicitors though, and barrister. And if TRAG wins, then the council will not have to pay more than £25,000 towards TRAG's costs. But we would hope that the proceedings would be within that £25,000 limit. So, does anybody have any questions?
Yeah, the judicial review, can they look at the two questions that you have on the slide here, or can they look at the dubious planning decision, the relationship with Solon and the RSU, whether they look at driving?
Yeah, there was one ground that we refused on, which was we were saying that given that the benefit, when the council goes through when they decide whether to grant planning permission, they have to go through this balancing exercise. The benefits on one side, the disbenefits on the other. And the benefit, in this case, one of the benefits was the delivery of this railway station in time for the Rugby World Cup. But one of our grounds was, well, if that's the case, you should have secured that delivery by condition, and you didn't do that. And so we have no way of keeping the developer to the 2015 timetable, and that's an unlawful approach. We say we refuse permission on that, but one can sort of filter that back if we have a sort of judge that's cooperative. You can try to argue that again.
But I have ground the planning meeting to actually, I mean, it was just bizarre. I was there, I was one of the people who got attacked, and it was absolutely bizarre. There they had, even the opposition gave them the reasons on the plate when they still granted it, and that's not the question why.
We are confined to essentially our grounds that we submitted to the court, so we can't really bring anything else in except, I mean, by way of factual background, but I say we have got permission on two of those, and we can try and argue with that more. Lady Isabel?
Yes, when the nature report was put in, or application by Solon, obviously at that time nobody knew exactly what was going to be put up. When the alternative scheme was put in, did that go through for planning permission as a separate item or to do with Solon? Has it been through planning applications?
Which one?
The alternative thing, our scheme.
This Plan B?
Yeah.
Our Plan B, that has not gone as a formal planning application, as I understand it. Yeah.
Is there some kind of buffer to prevent that when a major scheme has been...
What we're saying is that Plan B is what's known in planning terms as the material consideration, that it should have been taken into account, because if you can deliver something, a development in a way that's less harmful than another development, that's something that the local authority can take into account, and they may refuse the more harmful development as a consequence. So that's the way Plan B filters in. Gentlemen there?
So first of all, thank you very much for the explanation earlier on about the report. But a bit that eluded me just in the information there was, why is it that, on what grounds do we argue that the council are compelled to take into account the content of the TAP reports? I don't quite follow why it is that they must pay attention to it. I mean, I know
because it's a material consideration,
right.
And for the decision to be lawful, members are required to take into account material considerations. If they don't do that, then that is potentially unlawful. Because otherwise, if you decide something,
yes.
And there's a big gaping hole in information, or I mean, there's all sorts of material considerations are numerous, wide. There are lots of things that could be material considerations, and the council, in ruling out consideration of this TAP report, which was highly relevant, we say that was an unlawful approach because they didn't take it into account, and they should have done.
Okay, but my concern there would be that while I understand the point that you're making, so there's representing a view, but because it's not. So my sense of it is that it's not wrapped in some sort of legal framework whereby it's something that they must consider. A report is being produced, we present it to you for your review. You can choose to take account of it, or as they have done, they haven't taken account of it.
Well, you have to take it into account, what weight you attach to it is another matter. That's difficult to upset in the judicial review process. If you haven't taken it into account in the first place, that is the error, not what weight you attach to it.
Right,
so that's the error that occurred.
Okay, so I think then my concern is, again I follow what you say, so the concern then is that, okay, we will now take it into account, we choose not to attach too much weight to it, let's move on. How do we protect ourselves from that position?
Well, that's what will be happening if the decision is quashed, and then there is the planning committee meets again.
Right, but in order to arrive at the decision about whether to quash or not, so that they can look at the TAP report and say, okay, we need to take it into consideration, but how do we ensure that it carries the weight that we want it to carry?
You would make those submissions in your objections. You're saying this requires significant weight because the leader of the council set this group up this particular purpose, and look what they're saying. They're representing local opinion, and you must give it significant weight. But that will have to be addressed if we're successful in quashing the commission.
Okay. Although, sorry, the last bit from me. Although I think you mentioned that the leader didn't actually ask the group to provide a report, or did he?
I think he did, didn't he?
And I think was that a kind of catch?
Well, I mean, there is the view expressed by the Director of Environment is that they were not asked to prepare a report, but the TAP were actually set up, to act as Twickenham's honest brokers in considering, not just the Zolam redevelopment, but a whole raft of different planning issues that were going on, in terms of developing the blueprint for Twickenham. And when you actually read the report that they prepared, it's an incredibly well-considered report. Those people who sit on that committee are, fairly knowledgeable, skilled individuals, and I was impressed by the content of that report, and I'd implore you all to read, the appendices attached to that report. The report itself is a 15-page summary of a huge raft of in-depth research undertaken by them. Some of that information in there is better than the quality of information I've seen in planning authorities. Planning authorities' assessment of applications, and I think they captured all the deficiencies, quite well. When I wrote my own concerns and delivered them to the council on the 16th of December in connection with that scheme, my concerns were reported at the meeting on the 19th, and I had the opportunity to speak. Now, within that letter that I submitted to the council are a number of issues which I picked up, which were identical to what was contained in the TAG report, and I didn't have the benefit of seeing that until April of this year. So I think they did a sterling job in considering that particular scheme, and I think that they produced a report which they made it quite clear at a number of meetings that took place between Solum and officers that they were going to present the report on behalf of the community to the leader and to the planning committee members or officers dealing with it. So to say in April, they didn't have a remit to produce a report is a complete and utter nonsense. They could have said that in the meetings, the private meetings that took place, which are documented and are on public record.
We move on to another question about the process. That's, also, there are two grounds. That was ground 2 in the TAG. So there are other grounds which the analysis will be arguing in court. But what about the process? Are there some questions for us?
I just wanted to ask actually about the council's argument that the report wasn't produced in time and that he did not have time to read it for his updates. How much weight do you think that will hold in court?
Well, you're able to reconsider they resolved to grant in December, but didn't actually issue the planning permission until March. So they had the opportunity from December to March to feed that report in, and but they seemed to take the view, which was actually wrong, that they couldn't do that. So that again was an unlawful approach to that.
I rather sense from the remarks attributed to Lord True that he's embarrassed by his absence and his failure to look at the report. And I wonder whether it's open to the council to decide not to resist the application. But in that case, presumably, Solum is what Rick will tell us is an interested party. And it will fight tooth and nail to preserve the commission. Am I right?
That's right. The council could give up now and consent to judgment. To be fair, actually, they haven't submitted their detailed grounds for resistance, which they were supposed to have done. And some councils at this point would have given up. I mean, I suppose we could write to them and say, presumably you haven't filed your detailed grounds of resistance because you're consenting to judgment. So I'm sure that they may not have quite decided what they're going to do, I don't know. We could prompt them on that. But if they decided not to continue defending the claim, you're right, the interested party would, but that becomes problematic for the interested party because our attack is fundamentally on the council. If the council gives up, it's very difficult, not impossible, but very difficult for the interested party to continue on their own. So, I mean, if there's any political pressure that can be applied at this point, to the members, to feed into the officers to say, why don't we just give up now because, our costs aren't too great at the moment and,
So shouldn't we all now leave the room and go away and start lobbying our councillors in the wards in which respectively we live, with a view to their bringing pressure on the leader to have the effect of the councillors bringing it out?
I think actually that might be fruitful. I don't think it's going to be fruitful, but it might be productive to do that, because the leader is in a position to say, why not? Let's just go back and make a proper decision. Let's start over again and let's do it properly. So yes, I mean that might be a good thing to do now. If people feel like lobbying their councillors and the leader, yes, that could be productive.
Well, apart from giving money, which some of us in the room I hope will have done, to TRAG. Is there anything else that we can do as a panel?
Well, I'm sure that's a good idea. I mean, if you're a claimant, it's exactly a strong position to do that. But in fact, when we did see it, as I mentioned before, and we did say at the meeting, they said, if you go into judicial review, we're going to stop this meeting. And so we've taken that as they meant that, and I think that's been the case. Otherwise, I think they would have suggested another meeting.
Ian, sorry, not Ian.
So I was just saying that we did have meetings with the council at one stage, and it was made very clear during those meetings that if we went into a judicial review process, that it would be, we couldn't meet anymore like that. So that's rather put us off trying to meet again, but any pressure to get them to change their mind in the way we were talking about it, of course, a very good thing from our point of view.
Are we right to our representatives on the council?
Yeah.
And directly to the leader. And, you know, say permission's been, you understand permission's been granted for judicial review, and isn't this now time for the council to you know, do the decent thing and consent to judgment that would save costs? It actually would save costs at this point. If we're successful, they're in for 25,000. We haven't incurred 25,000 yet, so it would be a saving of taxpayer money.
Has Vince paid got an influence over this?
He might have an influence on the leader, so yes, potentially, yeah.
We have met Vince Cable several times, so he's very aware of.
And what's his position?
Well, he's very sympathetic to what we have been doing. I haven't seen him since the judicial review was allowed, but that's been my understanding.
David Cameron yesterday was talking about fast-tracking local complaints to new building ideas or structures. He seemed to be suggesting that that would be an enforcement activity fairly soon. Would that affect anything that would be in the way we're going forward?
No, I'd be very surprised if that comes into all. You know, there's all sorts of problems that we have to get over. For example, the Aarhus Convention on Access to Environmental Justice, which is also incorporated into our UK law via European law, and I think that's going to be very difficult to do. So it's just, I think that's just a bit saber rattling or, you know.
I would have thought it was worth writing to Vince Cable. He's only down the road. So I would have thought he must have a point. And I would have thought he'd have some influence over this.
Yeah, we have been in touch and I'm touching
Now, what I'm saying is for people to write.
But people to write to him, can always write to him. He's actually very good at replying as well. Someone at the back has been wanting to talk to him.
Back to an earlier statement you made about the council having to present their defence, which they haven't done yet. What was the time frame for them to do that? And when, and does that count against them that they haven't
Well,
done
they had to do it, I think it was within 14 or 21 days of the 21 days of commission, so they're actually out of time to do that.
By how long?
About a week, yeah. But they will probably say something which the court will... They filed summary grounds of defence.
Right.
And so it's quite likely that they will say they will rely on that. I mean, that's all they can do at this point because they're out of time for detailed grounds. In fact, their summary grounds were quite summary. So, we would be objecting
Does it make you feel confident?
File detailed grounds.
Marshall.
Was the planning committee of the 19th of December misled? The preparatory material for that meeting said that the TAC report had not been received at the time of writing. You've established that it was sent on the 9th of December. When were the notes prepared for the planning committee written?
They were actually written up on the 9th, so the day that the report came in. was the day that they were preparing the report, the officer's report. But notwithstanding that, there is a requirement for any supplementary information that's submitted, right up until noon of the day of the meeting, to be reported to members. So there was an opportunity for that report, even though it came in on the 9th, to be reported to members through the process that exists, right up to the 12 o'clock deadline on the day of the meeting.
The implication of the meeting notes is that if it had been received in time, it would have been included. Is that not the case?
I think that there are still issues whereby the Director of Environment, claims that this particular report was not, he argues that it was not presented to the officers, and it was a report that was purely prepared for, Lord True. Because Lord True wasn't available, they were unable to, look at it and comment on it. But I think, Susan's made the point that, the 19th of December was only the granting of a resolution. It was not actual planning permission, on that particular day. They then had a process of negotiating the 106 agreement, so the decision was only granted on the 29th, 30th of March. That's the day when the planning was granted. There was ample time between the 9th of December and the 30th of March to bring that to members, and there was a requirement for them to do so because it was material. They chose to ignore that, but that's...
We have one question here, and then one on that side. I'm just trying to realise a lot of hands going up. What about your question?
So the meeting of the 19th of December, I was one of the lucky few who was able to attend, and it seemed to me that the meeting was definitely misled in terms of public opinion. So public opinion through the website submissions was misrepresented, and some of it was ignored, and some important aspects of public opinion were ignored. Now that's against, that's in contravention of the council's own documents about how they're supposed to proceed, how they were supposed to proceed in this claim. So my question is there a precedent for overturning? Is this the kind of thing that works in a judicial review to have these decisions quashed?
I think that the three grounds that we've identified in our judicial review are the best grounds that we could find, the most attractive to the court. So, and it's, if you're saying do you want to bring up something out,
Well, no, I'm just wondering, I'm just asking what you guys suppose, what you think, what the precedent is, what the chances.
Well, I think that it sounds like the meeting was well aware of, the strength of opinion.
But they didn't discuss it.
Pardon?
They didn't discuss it.
Yeah, but it was in the officer's report, I think. The key document has been to looking at the judicial review is the officer's report, what was stated in there, and then also what happened at the meeting to supplement that as well.
Thank you. There's one right over there.
I might be taking someone to
Behind, after you, there's someone behind.
Mine's mine's at 6 here, but my understanding of what you're saying is that even if we win and the thing is quashed, then it goes back to the council, and then they can just look at that report and ignore it and
Well, I don't think they can ignore it.
well, they can ignore it, but they can still go on and grant this solemn proposal if they wish to. That's okay.
I'll just say one thing regarding that. After this decision was made, and there was the sort of public outcry, that both the Director of Environment and Lord True, went on record to say that, it's unfortunate, that this consent has, been granted. We've done the best to negotiate it down in terms of height, but anything, that's coming, forward from now onwards in the borough will be dealt with on the basis of the now adopted plan, development plan. It's pretty fundamental. We will still have an opportunity to comment on those applications, or the application that's submitted, if it's resubmitted in its current form, we will have the same objections to raise. The TAG report will be presented, and the council will then have to make its decision on the basis of public opinion and those reports. I think it's highly unlikely, but I can't say for certain. I think it's highly unlikely that any applicant will come in with the same application. There is an opportunity for them to reduce the height of that building. There is an opportunity for them to reduce it. It is financially viable to do so. There were other, bits of money available through Section 106 agreements when the rugby ground was extended, years ago, which run out in 2 years' time. There's still £580,000 worth of, Section 106 money available for transport improvements, which TAB asked to be brought into the station scheme in order to reduce the height down by a story. So there are mechanisms available to them, and they should seriously look at that. Whether they will do is another question. They may not be prepared for the fight. I suspect that Solent will wander off and go and find an easier borough to deal with, because they're dealing with 9 or 10 stations throughout the London area. And unfortunately, if they're going to be faced with a big fight, they may just well walk away from it.
I'm clear we'll get in touch with the council and the different people when this matter is decided, whichever way. But you've got time for a few more questions. I think and what about the gentleman that way in the back with him this time? We're concerned about him because he's putting his hand up.
Has the barrister who represents TRAG, has he or she offered an opinion on our chances of success in the jail?
I think that's a matter for that is a confidential matter, so I'm not going to disclose that. But what I would say is that the court has found the matter to be arguable. So that is a big hurdle to cross. So if you're looking at sort of prospects of success, we have overcome a sort of major hurdle of getting permission for judicial review. And a lot of cases don't get permission, so that is quite a high hurdle.
Okay, should have three.
Following up on this gentleman's 19th of December meeting, surely they could have put in bigger parts of accommodation at York House than where it was held, which was insufficient space for the people who wanted to be there.
Well, yes.
I think they've acknowledged that, and they have offered their apologies to those people who weren't able to attend. And I think in future, they will probably use Clarion for dealing with applications of that magnitude.
It's just one of them actually attack the room with their own representatives.
Well, we're talking about legality and just one last question.
Can I ask, the view from Richmond Terrace will be affected by this tower block? Has this not been considered?
It has been considered, and in the eyes of the officers dealing with the application, they felt that it would not have a detrimental impact. We did present some photographs of the before and after, using a photo montage technique. But unfortunately, they feel that it would not have a significant impact from the Richmond Hill Terrace view.
But the Richmond Society prevented other buildings.
That's right. That particular reason for refusal has been used on numerous occasions on a lot smaller schemes in Twickenham, I can assure you. But it shows, this particular case, they failed to take that into consideration.
We don't get any help from the Richmond Society.
Well, it's a kind of subjective view. I mean, we're dealing in our judicial review with procedures rather than a subjective view, and that's essentially what we're looking to fight here.
Thank you very much, and thank you.